Your reaction to the verdict?
Well, obviously, we're disappointed in the verdict, although we're pleased that they acquitted him on the top count. The significance of the grand larceny in the first degree was that it would require mandatory incarceration. So while we're disappointed with the outcome, we have another day to fight.
What's his status in terms of what he has to do in terms of complying with what was issued today?
I'm sorry.
What does he have to do in terms of compliance going forward now? Is there any change in his status? Right
now, at this moment, there's not. The district attorney has made an application, or at least signaled to the court that they want to make an application for bail. We obviously are going to resist that. Mr. Haggerty's been here every day. I mean, you guys have gotten photographs of him every day coming in and out of the courtroom. As I mentioned in the open court, at the very outset of this investigation, he cooperated fully. He went into the district attorney's office and at least 2 occasions cooperated with them when they went out to his house to search. So there's been no indication throughout the course of the last 15 to 18 months that he has any inclination to not cooperate or not be present.
Grounds for appeals?
What is the sentencing?
We will appeal.
What is the sentencing guidelines for the C felony?
Well,
the
first
possible is what?
Probation.
Probation after 15 years, is that correct?
Yeah, I mean, there's no mandatory minimum requirement. I mean, the B felony, the grand larceny in the first degree of which he was acquitted, would have mandated at least a minimum term of 1 to 3 years in state prison. So, fortunately, we're happy with that outcome. We're exceedingly happy that the jury did not convict him on the grand larceny in the first degree, and as I said, we're nonetheless still disappointed of the conviction on the second count.
Are you going to appeal?
Yes.
When do you have to be back in court regarding sentencing?
He didn't set a date yet. We're going to be back in court later this afternoon on the issue of bail. So we'll be back here at 2 o'clock, and that's why I got to go to work.
Is he out on ROR right now?
Yes.
Thank you, sir.
Correct.
What time are you coming back?
2 o'clock.
Thank you.
Thank you.
What do you?
Count that required mandatory incarceration, then he was found not guilty of that.
So when is juror said to me, I found this kind of interesting, because I don't think the DA explicitly made this, and I don't think he will even have that he said they believe that the IP was an agent. That's why the rate was made.
Yeah, what is the
do you think
legal
about
response to that? Yeah.
They believe that the IP was an agent of Bloomberg. That's what Mr. Conroy's oldest name.
I'm sorry?
Mr. Conroy, Stephen Conroy?
Well, that's startling to me. That's startling to me because there is absolutely nothing in the record which would indicate that the Independence Party was an agent. And while I have maintained from the outset that the $1.2 million contribution was not illegal, indeed, if the Independence Party was an agent of Michael Bloomberg, that contribution was illegal.
But does it legally mean anything that he thought that, or one juror, had that impression?
It's startling to me that after 4 weeks of testimony, after 5 hours of summations, that anybody would walk away with the impression that the Independence Party was Michael Bloomberg's agent. And quite frankly, that is a frightening concept, that the Independence Party, the state Independence Party, would be the agent of an individual who's running for mayor.
But can you appeal on those grounds that that's what
we'll see.
Head?
We'll see. Thank you.